Well, I think the state has an issue that they want to talk to you about. So I don't think they want to ask for any time for the whole year.
Oh, no, this is going.
Well, I think they've got a legitimate argument. And I hate to say that, but I think it's a fair argument.
Judge, so, and I guess we were gonna have this hearing closer whenever we were about to go on this. So we subpoenaed two witnesses in this case yesterday. We have a jail call last night from the defendant telling these witnesses not to appear.
All right, that sounds like forfeiture by wrongdoing. So the confrontation clause doesn't apply. So what's the issue?
So that was just something that we were just gonna file a motion, Judge. I just hadn't had the time to work.
Oh,
on it,
okay.
Just because it was pretty short notice. And we had just uploaded the jail call just because it happened
Okay.
last night.
All
Well,
right.
I mean, this is new information to me, and this changes my way of doing the case, and I am not ready based on that information.
All right, we're going forward. If somebody makes a jail call allegedly last night, this wasn't a jail call that has been sitting around forever. If it's a jail call that was made last night, state wouldn't know about it until they looked at it.
And I wouldn't know about it until this morning.
So you all are on notice. He's alleged to have made a phone call. You have it. Have you turned it over to the defense?
My understanding is that our paralegal uploaded it in the case or
Oh,
either
no.
this morning.
Just have them give it to him now. Let him listen to it. Let his client listen to it. This case is going to trial. He's been in jail and this is 5 settings, so it's going.
Judge, the only other thing, so we did get discovery, there was a co-defendant in this case. The discovery mainly pertains to the co-defendant. That's what I've been uploading this morning as well, but we weren't gonna use any of the co-defendant items.
This is going to trial today.
So let me just be clear, I'll need to make a record. I believe the state of the law is I'm entitled to time to prepare for a trial. I believe that's under the due process costs and due course of law.
Mhm.
I have not had time to do that. It will adversely affect my client. I understand you have the absolute right as a trial judge to call my case. I cannot keep you from doing it.
Mhm.
I don't prefer to do things twice.
Yeah.
So that's why I'm
This-
raising the issue. with
I
you.
understand what issue you're raising. This is going to trial. If he made a phone call allegedly
Well, I don't know.
recently, well, we're gonna find out. They're gonna give you the phone call. He'll be able to listen to the phone call. But if he made a phone call last night and it's something new that they didn't know about beforehand and they're just getting it, it's going. So
That's an interesting interpretation of the law.
I know, I appreciate the interesting interpretation, but that's what happens when clients make phone calls from the jail and think that the phone calls are not recorded. When it clearly says when somebody's making a phone call, this phone call is being recorded. And then the person on the receiving end of the
Judge,
phone call.
I
it
understand the
says that.
argument. I'm simply telling you as a litigator
Mhm.
that it changes the trial strategy. I believe it does affect his due process rights, and I will want to make that
Well,
absolutely, as they put it, there is no other kind of clear but crystal on the record.
oh,
And then you may overrule that.
Yeah.
I may then cite the case law that tells you you're wrong. You may ignore that and then.
Oh, let me just tell you what's gonna end up happening. I'm not hearing any motions for continuance unless a motion for continuance is filed and filed properly. And number two.
Well, now, how
once
would
that-
how would I do it in writing when I just found out about it? All right, so I will go back to the office and I will prepare that motion for continuance and I will
And
do
then
that.
I will hear it. And if I'm telling everybody, if that motion for continuance is based upon a phone call that he made last night, this trial is going. All right,
Okay,
who's
well-
here on Janelle Williams?
What I do know is that I am now being placed in a position where I haven't looked at what they're saying. It isn't whether they're going to present it, it's whether it's material to our defense. And I don't know, Judge, but what I do know is that I prepared by uploading each and everything in the case to this drive. And when there's additional information, I'm very concerned about going forward. It's the whole reason that we signed those discovery acknowledgements, which I cannot sign today.
The courtroom was basically a live comedy show, with the lawyer trying to act like surprise recordings are some groundbreaking injustice, when literally everyone knows jail calls start with the big friendly, "This call is recorded" warning. He rambled about fairness and due process like he'd just discovered the Constitution yesterday, while the judge calmly swatted away his theatrics like a fly. Instead of wasting time on pity speeches, the judge kept it real. The call exists, you'll get it, now stop stalling and move on.
But what he's saying is that it's already been uploaded. And it wasn't just uploaded today, that you already have it.
Well, everything that is on this drive is what has been uploaded in this case, and I am on notice that we are trying today. I believe that evidence It might be to another case, might be somewhere else. But I asked them, and I've been in open court and said it, I want every piece of information on this case. So if they're intending on bringing information from other cases, that was the reason that I went here today and said, what case are we trying? And I want to be prepared on it. On the the forfeiture thing, I actually pulled the number of subpoenas that have been done today. I went to the district clerks.
Mhm.
And there's only one subpoena requested on file on this case. I have a copy for the court. It's on Emily Rose Fritz, which is none of these individuals, and there's a return on her. So if there has been a subpoena done, I wasn't on notice of it. Of course, what I would have done is I would have discussed with Mr. Estrada, you can't mess with the witnesses. But I can only prepare him for what is in the records. In other words, there is no record of these people either being a subpoena being requested or issued.
So is your argument that if there are witnesses in a case, unless they're subpoenaed, a defendant can tell a witness, don't show up?
Well, if a person has not been subpoenaed, the law allows you to tell them you don't have to show up.
No, not you don't have to show up, but tell them not to show up. That's what the allegation is, that he told a witness not to show up, not that you don't have to show up. I've been a defense attorney and I know that people have told people, hey, you haven't been subpoenaed, you can show up or not show up. If you've been subpoenaed and you don't show up, one or two things are going to happen. Either the state is going to be like, well, whatever, they didn't show up, or either they're going to want to do an attachment.
So I am returning to what I know to be the law. And the law is that we are entitled to two things. Number one, all the discovery on a case that we've.
I'm talking about the asset,
Yeah.
the forfeiture.
So the forfeiture by wrongdoing,
Mhm.
I do not know whether, because and I have a case here that the standard is that it has to be wrongful, right? And so the question is it wrongful? Well,
Well, the question is it wrongful to tell somebody that they don't have to, that they don't show up to court? Is that wrongful to tell somebody, do not show up to court? If you show up to court, then I'm looking at 25 years. Is that wrong to do?
I believe that is the question. If that is in fact what it said, which of course is the real problem we have here. So what I don't like to do is I don't like to be at the last minute. They're saying it's in some other discovery. I don't know that.
No. I want to talk about this forfeiture by wrongdoing. That's what I want to talk about.
Yes, ma'am.
So let's figure that out. And then we'll come back to this discovery issue.
Okay.
So that's my question. So basically, and I don't know if this is your argument or not. So are you saying that if there's somebody in custody or not in custody on bond? Well, no, let's say they're in custody. That you get out of a trial, all they have to do is, if your trial is on, let's say hypothetically, February 6th, you can call somebody on February 5th and tell them not to show. And then the defense attorney can say, excuse me, I need more time. I'm just learning about this. And then let's say hypothetically, that person gets a continuance and their continuance is, let's say it's for March 12th or whatever. I'm just doing a date. And so that defendant knows their court date, their trial is set for March 12th. So they say, you know what? Let me make a phone call. And they make a phone call on March 11th, telling somebody not to show up for court, because if you show up for court, things are not going to go well for me. And then the defense attorney can come in and say, hey, I just learned about this last night. So are we going to do a situation, hypothetically, where defendants are allowed to call people the night before their trial, tell them not to show up for trial, and then everybody gets a continuance because I'm just learning that they told somebody not to show up for trial? And these are just questions I have, Mr. Estrada, and these are hypothetical questions. I'm not saying you did that. I don't know. No evidence has been presented of me, but I'm just trying to figure out everybody's legal thoughts on certain situations.
This was one of those moments where the judge turned the courtroom into a logic masterclass while the lawyer tried to juggle excuses like they were auditioning for a circus act. The judge cut right through the smoke. So your plan is defendants can just call up witnesses the night before trial, tell them don't bother showing up, and magically get a continuance because the defense just learned about it? That's not legal strategy. That's a how-to guide for sabotaging justice. The judge's hypotheticals weren't just sharp. They roasted the whole flimsy argument alive.
Judge, I started out a long time ago thinking I knew everything about the law.
Mhm.
I have been dispossessed about that idea.
Oh,
Hey,
me too.
The answer is I don't know.
Mhm.
And when I say I don't know, I'm being straightforward and honest with you. I do not know the status of the law. I do not know the status of the subpoenas. I don't know this issue. And this issue popped up at the last moment. And it did pop up at the last moment.
Well, Mr. Brabenec, not to interrupt, but I will tell you, I know the law on that unless it's changed. You know why I know the law on that? Because when I was a prosecutor, and Ms. Ferguson will tell you, on family violence cases, you would think you have a witness, they've been subpoenaed, then all of a sudden they don't show up. You check jail calls, and the night before, whoever the defendant is has called that person and said, do not show up to court. If you don't show up to court, they're going to have to dismiss the case. And you know what I would do? I would play the DVD in court and say, here's your motion. I'm doing an affidavit. I'm doing a forfeiture.
The law
by
didn't
wrongdoing.
change, in fact, since you've been a prosecutor, because I know you've been a judge at least 4 years, right?
Yeah, more than that. But
Okay.
I always try to keep up to date on law. So
Well,
I reviewed it.
so your specific hypothetical was about when you were a prosecutor and you knew the knowledge was from back.
Oh, but here's the thing. I'm telling you that because I have background and forfeiture by wrongdoing, and I always keep up on forfeiture by wrongdoing. And the reason why I do that is because I'm anticipating that usually that happens in family violence cases. So I always check the law every now and then. And then, hey, who knows? Maybe something's changed since yesterday. If it has, I'm willing to be presented with that and keep an open mind on it. I'm always for following the law.
Well, so it has changed since you were a
Mhm.
prosecutor, which is where you let me know, and it changed in 2021.
Mhm.
I can't tell you in this specific fact because I've done not a briefing. But you had already indicated to me off the record that you were not going to grant a continuance on this particular
No,
ground.
not on, not because you've got new information that your client allegedly called someone from the jail last night on the 5th. At least that's what's in your motion too. On the 5th, I believe, asking somebody not to appear for trial.
But Judge, as you know, when I wrote this, I hadn't listened to the audio tape yet.
Okay.
So it's very difficult for me to make a good legal argument when I have yet to look over the things or read the things. Which really brings, since you had already told me you weren't going to grant a continuance on the thing that you are now indicating you're not going to the grounds that you should grant a continuance, which is that I don't know. They're telling me there's new discovery that they don't believe is material. I'm telling the court I don't know. I'm also telling the court I prepared. I'm telling the court I downloaded everything. I'm telling the court that now with this new information under Michael Morton and under the Texas Supreme Court cases, I believe I'm entitled to time to review it.
Mhm.
And I'm not asking, I've been a trial lawyer 24 years, which I believe is a little less than you,
Mhm.
but I'm not asking for a lot of time. I believe in a week I could be here standing and say, Judge, I'm ready. They were right. Or Judge, we've got an issue. And if there's an issue, I'll come by on Wednesday, Thursday, Friday, as soon as I can. In other words, I'm not going to let it sit out there. But at this point in my career, I am unwilling to take the other side telling me that something is not material to my client's case
Mhm.
and is not important.
You're coming back tomorrow for trial. That's the time you have. So whatever he needs to see, he needs to see it.
Yes, Judge.
If he needs to listen to that video, the audio from the jail, he needs to listen to the audio from the jail about your request for forfeiture by wrongdoing. Y'all are here, listen to it. But you're coming back to trial for tomorrow.
The judge handled this like a seasoned pro swatting away excuses with the kind of calm authority that makes 24 years of trial experience sound more like 24 years of procrastination. While the defense was spinning in circles about not knowing this, not reviewing that, and needing a week-long grace period to catch up, the judge basically dropped the mic. You've got until tomorrow, listen to the tape, then show up ready for trial. No grand delays, no endless law school lectures, just pure courtroom efficiency. It was a masterclass in how to cut through lawyerly stall tactics and keep the wheels of justice rolling, whether the defense is ready or not.